Daily list item 1.
My lord, report was called for. This one.
It's okay. Okay. Is that holding center at 7th AP Battalion? We give you visitation right.
My lord,
The person is at the holding center at 7th AP Battalion. We give you the visitation right. After order of visitation right. Mr. Your name?
S.U. Ahmed.
S.U. Ahmed, Learned Constable Petition, and the respondents are there. This is it, present location at 7th AP Battalion. So visitation right with one family member of the petitioner with one family member. To sign Vakaratama. No problem. List on. Give a date after 10 days. List on so and so. We are giving a visitation right on this instruction produced by Ms. A. Verma, Learned Standing Counsel for the FT matters. The same is kept as part of it.
Obliged, my lord.
15.9. Item 2.
Please, the lordships. Stable pin is something.
My lord, in this case, I had approached this on court earlier, my lord. And my lord, during that proceeding, my lord, that was informed that, my lord, I have been, my lord, she had been pushed back, my lord. The petitioner's husband is before your lordship, my lord.
Yes.
She was picked up on 24/5/2025, my lord.
Yes.
And initially it was informed that she is in a holding center. Later on, my lord, it was found that she has been pushed back, my lord.
Yes.
That's why I filed a subsequent writ petition, my lord. But there is no record, my lord. They could not produce any record of, my lord, that she was handed over to the any Bangladeshi authorities, my lord. Nothing of the sort. Only it was informed that she was pushed back. So therefore, I filed this subsequent writ petition, my lord.
Lordship, I think there was no direction for us to get any instructions how he was pushed back or.
That's why I filed the second subsequent writ petition, my lord. My lord, it violates their own policy, my lord. In fact, page 57, my lord, is the affidavit which was filed.
Already, if you passed few orders,
My lord.
I believe you have got the, you have seen the orders we have passed earlier.
Of course, on my lord, my lord, I have not, my lord, seen them. Sorry, my lord.
Okay, we are issuing a notice, you just respond to it.
Lordship has already dealt with these matters. Lordship has
Absolutely,
passed
but since he is not aware of it, we'll issue a notice, we'll take it up after 2 weeks.
after 2 weeks. Yes, Lordship.
Heard Mr. M. Datta, Learned Counsel for the petitioner, as well as Sunso for the respondents. Next, alleging that the wife of the petitioner, namely, Dojan, D-O-Y-J-A-N, Dojan Didi, was sent back to Bangladesh without due process of law. The present writ petition has been filed under Article 226 of the Constitution of India. Issue notice returnable on. Give a date after 2 weeks. You'll be able to file a response by then?
Lordship, AG has already argued the matter. The same argument would be taken up and on which Lordship has passed many orders.
When do you want?
Lordship will take this up after the Puja vacation, Lordship. By then we will file, Lordship.
After Puja vacation?
Lordship has recently passed in
No, we understand. but,
32 and 37, Lordship.
No, we understand, but still, if Mr. Datta does
I
not.
think we'll have to ask the AG to come and appear, Lordship.
After
It
vacation,
would be
we'll
of
go
the
to,
same lines, Lordship.
it'll go to 15th of October then.
Yes, Lordship, that is okay.
Okay. The issue notice returnable on 15/10/2025. So extra copies within 2 days. List on so and so. You want us to issue notice on the Advocate General? No.
No.
No, we'll inform him, Lordship.
Okay.
Obliged, your lordship.
Item 3.
That is the lordship.
Yes.
Lordship, I was detained under section 3 subclause 1 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, lordship. The white order dated lordship 5/6/25. Lordship will come to page number 15. The detention order, lordship.
So you're challenging the detention order.
Lordship,
You're challenging the detention order.
yes, lordship.
Okay. Your name?
M. Rahman, lordship.
Mr. M. Rahman, Learned Counsel for the petitioner, also heard. Mr. P. Sharma, Learned Additional Senior Government Advocate, appearing for the respondent numbers
Except 3, my lord.
1, 1, 2, 3.
1, 2,
No, 1, 2.
3,
No, 1, 2,
4.
and 4 to 8,
Yes, lordship.
as well as don't say that. Heard so and so for the petitioner. Next paragraph. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely Shiva Bhuya alias Sujal Bhuya alias Shiva Bhuya, has assailed the detention order dated 5/6/2025, passed by the Secretary, Home and Political Department, Government of Assam, under PIT NDPS Act, 1988. Issue notice returnable on, you give a 10 days time. Notice returned on 15/9/2025. Requisite extra copies. The extra copies as well as soft copy of the writ petition with all annexures will be provided to the learned. No, don't say that. Issue notice returned on so and so. Next paragraph. Mr. P. Sharma, learned additional senior committee advocate, accepts notice on behalf of respondent numbers 1, 2, and 4 to 8. And Mr. K.K. Parashar, learned CGC, accepts notice on behalf of respondent numbers 3 and 4. So requisite extra copies of the writ petition as well as soft copy of the writ petition with all enclosures be provided to them in course of the day. Since detention order has been assailed, all the concerned respondents shall ensure that their affidavits shall be filed within the next returnable date. So accordingly, the learned additional senior government advocate and the learned CGC shall transmit a downloaded copy of this order to the concerned respondent authorities to bring the order to the to their notice. Next list on 15/11/2020, 15/9/2025.
My lord, may I pray for interim release, lordship, because section.
Fit NDPS.
Lordship, section 3, subclause 3 was violated, lordship, but prima facie it was violation, lordship. So
No.
that matter relates to section.
You want us to
Article
record the
22,
rejection? You want us to record the rejection?
No, lordship.
Item 5.
Oblige, sir.
The 4 to key mention provision
Okay, then we'll directed to file affidavit, bring the two orders similar. I have I am going to file a additional affidavit, Miller. Already.
Just first the orders.
Yes,
Hmm?
last order. Miller.
No, not the last order. The orders you want to produce.
Yes, Miller.
First that.
Yes. Two orders and one is annexed with the writ petition and two orders is in the additional affidavit.
For that.
Copy distributed,
Oh,
additional affidavit, copy.
It-
Additional affidavit, copy. Other filers association. Five.
I said no, wait.
Be serious.
How much time you require? How much time?
Up to 3 days, Miller.
Should we fix it on Friday?
Yes, Miller.
Okay. On the prayer made by Mr. A. M. Ahmed, the counsel for the petition, list on 5/9/2025, so as to enable him to file an affidavit in terms of the previous order. All the respondents are represented.
Item 6.
That is the copy দিব হ্যাঁ
Dim. আমার কপি দিলেহে ফেলে হবে।
আর এটা দিব একো নহয় আমার হেৰাই আছে এটাই লাগে
May please, your lordship. Lordship has heard the matter, yeah, they want to argue, my lord.
Lordship, Mr. Pine would be arguing this matter. He's not in town today, Lordship. Lordship may fix up a date. He's gone out of station, Lordship. Lordship? Yes, Lordship.
Day after tomorrow, কি হয়?
Third.
My lord, heard, my lord. Heard of some problem, okay, problem, maybe. My lord, I am available.
I'm liquid. Where should you get a job?
My lord,
Item 7.
maybe. No problem. Impugned order, my lord. May, this is annexed 2, my lord, page 17 is the impugned order.
By preferring this writ petition under Article 226. The opinion dated 17/12/2024 at page 17 has been assailed. Issue notice. Since the respondents are represented. Number 7. Since respondent number 1 to 6 are represented, formal notices on them are dispensed. However, extra copies within 3 working days. Respondent number 7 does not appear to be a necessary party for adjudication of the issues raised. Therefore, respondent number 7 is struck up from the area of parties. The learned counsel for the petitioner prays for interim bail. The petitioner, which is opposed by the learned standing counsel for the FT matters. However, in view of the projection made in the writ petition, we are inclined to grant bail. The petitioner shall appear before the superintendent of police border, Bongaigaon. Filling which the bill shall stand recalled. Call for the TCR. List after 4 weeks on receipt of TCR.
Boss.
Mr. Rashid. We have striked out the name of respondent number 7. If her presence is there, your petition can be dismissed in limine right now. You know the reason? You want to know the reason why we are saying so? There's no material on record that you were present and you were present before the tribunal. There's no record of that.
So because your Lord should write on the fixed dates, my
So
lord.
we are
Only
giving
I
we are
appear-
giving a choice. We have passed the order, but you are giving your choice. You want her to remain or you don't want her to remain.
But actually, my lord, I, as an advocate, my lord, myself, do not like to implicate another advocate. But
No, that's
I am
your,
compelled.
no, I am not asking your personal choice. We have strike out the name of respondent number 7. You want her to be there or not?
No, okay.
Well,
Item 9.
Wait, please, it's a loss. Please 25 minutes. Expert order.
2009 order, Lordship.
2009.
My God.
My lord.
Lordship. Lordship will hear and dispose of this matter today only, Lordship, now. 2009, Lordship, it's 19 and then again almost 16 years, Lordship.
Well,
15,
apart from the
16
delay,
years.
my lord, we
To the judgment of the NRC to inclusion does not grant citizenship. If it's NRC is NRC, so but if he's a declared foreigner, how can he know this? He or he could say more. Idea. So, that's a good papa. You could flip my house.
Your explanation is something we can't accept.
My lord, apart from the delay, my lord, this is the prima facie, my
No,
lord.
once that is gone, everything is gone.
NRC is there, my lord, and my lord, the legacy that also is there. My lord.
You
Accepted
had
it.
an opportunity. It can be extended for
Paragraph
15
7 and
years.
paragraph 7 and 8, my lord. I
We have seen that.
Well. And COVID also is there, my lord.
COVID, 2009.
My lord, he, my lord, come to his knowledge, my lord, only on my lord 20.
No, unfortunately, you see, normally in our proceedings, in the High Court, we don't have material exhibits.
My lord.
We want to see one.
False.
You want to see a material exhibit.
My lord.
Normally in the High Court, there is no evidence, there is no material exhibit. I'm asking you want to see one material exhibit? You are addressing the bench,
My lord.
out of which one member, that is I.
My lord.
I am sitting here with a slip disc for last 4 years.
My lord. My lord, he will suffer, my lord, otherwise, my lord.
No, that's why I'm saying
No.
that doesn't mean that for illness somebody will not come for say 15 years. What is that illness of 15 years?
My lord.
2009 notice was served, you say he became ill.
Unfortunately, my lord, he will not participate in the trial. That's why.
Sorry, we don't.
Oh, one last opportunity, my lord.
Oh, no, after 15 years, no.
Lordship, a very recent judgment of the Supreme Court, Lordship, which says that inclusion of the name, a declared foreigner's name cannot be in the NRC, Lordship.
No, those on merit will come later. Once we are satisfied with the delay, then we'll see the merit.
Billion Lordship of the Lordship.
Come to this, what is this annexure, 8, page 21, what is it?
This is Aadhar, my lord.
Whose? Who's Aadhar?
Oh, this is Chayatullah.
Who is Sayadullah? This man? Is it the same man?
Same man, my lord.
Same man.
My lord,
What is the date of birth?
Date of birth 81, my lord.
What is his age as of today?
Is my lord.
Please calculate. No. You calculate from the Aadhaar card.
81, my lord.
And what is Annexure 7?
Annexure 7 is a voter ID.
Voter ID. What is the date given in there?
80.
1911, 1980.
My lord.
Aadhaar card says 9/3/1981. Let us go by 9/3/1981. Aadhaar will take to be the correct one. What is the age as of today? 91, 2001, 2011, 2021, and another 5 years.
My lord, in my lord.
45 years.
My lord, in my lord,
No,
voter ID.
you see, we are very, very slow people.
My lord,
Mathematics.
Unless we ask you something and you don't explain,
my lord.
we are very slow in understanding. We ask you a question, you respond to it, then we will come to another thing. Two separate things we can't understand together.
My lord.
We have our limitations.
According to your Aadhaar, what is the age?
44.
44. According to your electoral card, it will be 45 because 1980 born.
45.
45.
Wow.
Now your affidavit.
Affidavit 56.
Take it as a fraud on the court. Take it as a fraud.
Power. Let.
Mr. H.P. Gwala, and counsel for the petitioner. Also heard so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner named so and so has said the opinion dated 9/4/2009, page 25, passed by so and so in so and so, district number so and so, thereby declaring the petitioner to be a ex parte opinion, it's so and so, declaring the petitioner to be a foreigner of post 25 in 1971. Next, for the learned counsel for the petitioner has submitted that the petitioner has a good case on merit. But unfortunately, after service of notice of the learned foreigners tribunal, the petitioner became ill and suffered a prolonged period of illness. And therefore, he failed to participate in the proceedings before the learned tribunal. So it is submitted that the petitioner has documents to show that he is a citizen of India. First off, his name has been entered in the National Register of Citizens. Accordingly, it is submitted that following the principle that no genuine Indian citizen should be thrown out of the country, the petitioner has prayed for setting aside of the impugned opinion. Thanks for that. The learned standing counsel for the FT matters has opposed the issuance of notice in this writ petition on the ground of inordinate delay and latches in preferring the challenge. Next para. on appraisal of the materials available on record, there is no document to show that what sort of illness the petitioner was suffering since service of notice in the year 2000, in the year 2009, which lasted for about 16 years, disabling him from taking appropriate steps before the Loretta Tribunal. Next paragraph. In the affidavits from in support of the present writ petition, the petitioner has declared his age to be 56 years, which is found to be inconsistent with the date of birth of 19/11/1980, recorded in the electoral photo identity card, as well as the Aadhaar card, which records his date of birth as 9/3/1981. Aadhaar card and income tax PAN card. 1981. Stop. Under the circumstances, in view of the projection of incorrect age of the petitioner, the same amounts to fraud upon the court. Stop. Therefore, on the ground of lack of any explanation about the cause of delay and latches in challenging the opinion dated page 25, open dated 9/4/2009, passed in so and so. And in view of incorrect projection of the age of the petitioner, which is inconsistent, the court is inclined to hold that the petitioner has committed fraud upon the court and first of accordingly, the writ petition stands dismissed at the motion stage without issuance of notice on the respondents. Next, the registry shall communicate a copy of this order to the learned member, foreigners tribunal -Roman 2. Lakhimpur, North Lakhimpur, to make it a record of LFT case number 32/08, arising out of list number DIST, list of number 3981 of 2007.
Item 10.
Okay. Not improvement of opinion is that case.
Yes.
Not, the improvement opinion at page 104, except 20,
Page 10.
104, and except 22. Because that opinion is given on 4/6.
22.
2022.
You have to wait for some time for bill.
Then it's to the Arts and so. Jeez. By preferring this writ petition under Article 226 of the Constitution of India, the opinion dated 4/6/2022, page 104. Issue notice. Returnable 4 weeks. Since all the respondents are represented, formal notices dispensed with, extra copies within 3 working days from today. All for the trial court records. The prayer for bail will be considered on receipt of the trial court records. However, it is provided that if in the interim, the petitioner is apprehended, she will not be deported without further orders of this court. List on. Huh? 15th October. With trial court records. Not to be deported. Not to be deported.
Item 11.
No,
नहीं, 23 beside extra copy
Lordship. Opinion at PSQL, Lordship. And this is an ex parte order, Lordship.
Twenty-six.
Motion of East Hall.
You are A. Ali.
Yeah, Ali.
Heard Mr. A. Ali for another counsel for the petitioner, also heard counsels for the respondents. By filing this petition under Article 226 of the Constitution of India, the opinion dated 26/6/2023, page 12, has been assailed. Issue notice. Returnable 4 weeks. Since the respondents are represented, formal notices dispensed. Extra copies within 3 working days. Call for the TCR by email. Prayer for bail will be considered on receipt of the TCR. However, in the interim, if the petitioner is apprehended, she will not be deported without further further orders of this court. List on 15th October, along with TCR.
Obvious.
Item 12.
May please go on. My lord, page
Just a moment,
88.
last matter, please, who was there, Mr. Ali?
Item 11.
Last matter,
Last matter.
Item 11. No?
yes. Sorry, we missed out something. We'll have to dismiss your writ petition in limine.
Lordship.
We'll have to dismiss your petition in limine. Page 12 is the opinion.
Yes, Lordship.
Yes, we missed out something. Come to this page 14,
Lordship.
reasons and conclusion thereof.
Yes.
The proceeding submitted a written statement along with photocopies of document after filing of WS.
Hmm.
She entered into evidence with the so-and-so with so-and-so,
Hmm.
correct?
Hmm.
Is this wrong statement by the tribunal?
Here, Lordship, accordingly, the reference was heard ex parte on 15th.
No, not that. We are asking you a question, please respond to it. We have read it, that therefore we are calling you back,
Lordship.
correct? You have doubt, we have not read it.
No, there is no
Ah,
doubt.
okay. There's no doubt that the proceeding filed a written statement.
Yes, there are
documents.
not appear.
No, that's okay. Don't hurry. We are not a bit in hurry. Come to paragraph 8 of your writ petition at paragraph 7. Give a copy to Ms. Verma.
None of us have a copy, Lordship, so we couldn't go through it.
Okay.
772, sir.
Your statement in paragraph 8 is, it is stated on behalf of the petitioner that the petitioner was absent because of notice was not duly served on the petitioner. So she has no negligence and there are sufficient causes preventing her to remain present on the date when the case was proceeded for ex parte order.
Sorry, Lordship, it is a
No,
copy
no,
paste.
no,
Lordship.
sorry. No, sorry.
It is copy paste from the other petition. Lordship.
Ah.
Lordship. I may be allowed to do, Lordship, and to file case.
जो है copy mistake.
I would like to do, Lordship.
No, you see, that can't happen. It's a major, major fault because you see, somehow we missed it. We messed up, perhaps because we are growing old.
Lordship. For my fault, the party cannot suffer.
No, this is not a fault. It's a sworn affidavit. While parting with the file, we remembered that there's something here. Every time you see, same thing, because you see from paragraph 5 of your petition, the same thing. It's not a mistake. It's a deliberate mistake. You never thought that we would be comparing this with documents inside.
Paragraph 5, Lordship.
5, 6, 7.
Paragraph 5, you say that petitioner, she submitted a written statement. Thereafter, she could not appear before the tribunal. So and so, so and so, so and so. Now come to the opinion. And para
Lordship.
13, last 3 lines. After filing of the written statement, she entered into evidence to prove facts stated in the written statement as burden of proof lies upon the proceeding under section 9.
Lordship,
Although-
all are bona fide.
Although there is a contradictory stand in the opinion, but since you don't read it, why should we tell you?
Lordship, all are bona fide newspapers.
No, it's not a bona fide mistake. It can't be a bona fide mistake. It will happen when you don't read the brief. It's not a bona fide mistake. You were callous and you are counting on that we don't have time to read. Oh, sorry, we won't give you that.
I
but-
would like to withdraw this petition.
No, that would encourage false statements in the writ petition that if I get caught, I will withdraw it. If I don't get caught, it sails through. It's something which is interference with the administration of justice. Can't permit that.
If he said, please just email the dismissal orders directly to concerned SP. Got the discipline order with CC to yes. This is necessary. How many people are just giving interim direction with temporary restrictions and deportation of selection? Maybe some.
Yes, Lordship.
Since you don't have a copy of the writ petition, we are sending one this copy to you. Giving a copy to you. See, page 13, we have marked something. Next page, page 14, we have marked something. Just read it for yourself.
Interestingly, none of us have the copy, neither election, nor government, nor me.
No, I did not check it in the last page. You see, these 2 lines, say that evidence was filed. Correct? Now turn over to the next page. In the middle, I have marked,
Yes, Lordship.
this is inconsistent.
Lordship may examine, Lordship, maybe call for the records.
No, we'll have to dismiss it, give you liberty.
Liberty, yes, Lordship.
Okay.
But you have to pay cost, 5,000 rupees cost to the bar, benevolent fund.
A lot of contradictions here.
Mr. A. Adil and counsel for the petitioner. Also heard so for the respondents. By filing this writ petition, the petitioner has assailed the opinion dated 26/6/2023, passed by so and so, page 12. Next one. We take notice of the fact that in the impugned opinion, the learned tribunal has recorded that after filing of the writ statement, the petitioner had entered into evidence to prove the facts pleaded in the written statement. And thereafter, no steps was taken. The said statement. The corresponding statement in paragraph 5 of the writ petition is that the petitioner submitted a written statement on 19/7/2022, and thereafter she could not appear before the tribunal because of her illness. Full stop. However, a U-turn has been taken by the petitioner to allege in paragraph 8 of the writ petition that the petitioner was absent because the notice was not duly served upon the petitioner. Full stop. When the said contradictory stand is pointed out to the learned counsel for the petitioner, comma, he prays to allow him to withdraw the writ petition. Next paragraph. Although when an incorrect and false projection is made in the writ petition, comma, the allowing of to allow the petitioner to withdraw the writ petition would amount to if premium to the petitioner for making a false statement in the writ petition. Nonetheless, considering that the issue of citizenship is involved, comma, the pair so made by the learned counsel for the petitioner is reluctantly allowed. Mr. However, the court is inclined to impose a cost of rupees 5,000 to the petitioner, comma, not to be recovered from the petitioner, comma, which shall be deposited before the benevolent fund of the Guwahati High Court Bar Association in a period of 15 days from the date of the order. Copy of this order be sent to the Guwahati High Court Bar Association. Next para. Prayer is allowed. The writ petition stands dismissed on withdrawal with liberty to the petitioner to approach the court again.
Item 12.
May it please your lordship. My lord, the order is at page 88.
There is some delay. You'll have to wait, Mr. Rajadri.
My lord, there are 20, I have given the.
It's okay. It's a little delay, but
Heard Mr. P.K. Roy Chaudhary, not a counsel appearing for the petitioner. Also heard the respondents. The opinion rendered on 23/2024, page 88, has been assailed in this writ petition by the petitioner. Issue notice returnable 4 weeks since the respondents are represented. Formal notices are dispensed with. However, extra copies will be supplied within a period of 3 working days from today. Call for the trial court records by email. The prayer for bail will be considered on the returnable date. However, it is provided in the meantime, if the petitioner, namely so-and-so, Elias so-and-so is apprehended, he shall not be deported without further orders of this court placed on 15th October along with TCR.
Fabulous.
Item 13.
May I please, your Lordship? Lordship, and you see the page number 59,
50?
next to 50. This is Interim opinion dated 31/7/25.
Is this page 32?
32, 59.
No, page 32, what is page 32?
Page 32 is final order
Of?
of my mother. My mother's,
Your name?
my name is Arkha.
R. Khan.
Kha.
Kha. Heard Ms. R. Kha, National Counsel for the petitioner. Also heard the respondents. By preferring this writ petition under Article 226 of the Constitution of India, the opinion dated 31/7/2025 passed by at page 59. Learned Counsel for the petitioner submits that on an earlier occasion, the mother of the petitioner had been declared to be an Indian citizen. Issue notice, returnable 4 weeks. Since the respondents are represented, formal notices is dispensed with. However, extra copies within 3 working days. Call for the TCR. And the counsel for the petitioner has prayed for interim bail, which is opposed to by the learned counsel appearing for the respondents. However, in view of the projection made in the writ petition, we are inclined to grant bail. The petitioner shall appear before the Superintendent of Police Border Lakhimpur. থাকিব। In case of non-appearance, bail will be purchased and lapsed. List after 4 weeks, along with PCR.
Obliged, madam.
I think so.
Item 14.
May it please your lordship. Lordship, opinion dated is 25/10/2019, page 33, lordship.
Mr. Arjun, you have a very good explanation.
Yes, lordship, I have explained page 24, lordship, serial number 29. Regarding delay, I have explained, lordship.
But we would have loved that statement,
Lordship,
except for page 35. Yes. Exhibit 3, 4, 5. We would have been sympathetic,
shall be Lordship, in well.
even except for that exhibit 3, 4, 5.
No, Lordship. Lordship, I have filed a review petition, Lordship, on 6/11/2024, which I annexed here as 20, Lordship. But till date, no order has been passed by the landed foreign tribunal, Lordship, and original petition has been returned back to me, Lordship, without passing any order, Lordship.
Where is that petition?
Page 89, Lordship, annexure 20. Page 89, I have filed a review petition, Lordship. And I have annexed other state also, Lordship.
Where is that?
Page 102 is the relevant person, Lordship. Annexure 21, Lordship.
Thank you for 24 policy. Just. Going to the.
Yes, Ms. Verma.
Yes, Lordship.
Page 102. Acceptable.
Problem 102, Lordship.
Page 102, this is not acceptable.
Lordship will take it up, Lordship. Member opinion.
This, Mr. Ajong is referring to this review petition. He says that it has been returned.
Yes, Lordship. Original petition is with me, Lord.
Where is that? Page 89.
Page 89, Lordship.
This is the second time we've coming across such a matter, Lordship. We'll have to take it up. It's just a time like that.
Same thing, do we ask the Home Department to seize the records?
Yes, Lordship. Petition not useful.
Yeah, okay. You have the original one also. Ms. Verma, under these circumstances, the only option left for us is to direct the Home Department to take the records, examine it. And if the procedure followed for returning, since we don't find it to be appropriate, we'll direct the Home Department to issue notification describing the manner in which documents are to be accepted and returned. Earlier also, we passed an order, and then we directed that this matter be taken up also in the infrastructure bench. Monitoring bench, yes. It's, I think, tomorrow. But, I mean, this monitoring bench is when? We fixed a date for monitoring bench. It is tomorrow or on Thursday. FT monitoring bench. Foreigners travel monitoring bench. There was a special bench. It's tomorrow, fixed tomorrow. Tomorrow. Okay. Then, though we normally are not inclined to give bail, but since we have this, we are granting bail also. Heard Mr. A. Hazam, learned counsel for the petitioner. Also heard so-and-so for the respondents. Opinion is at page 34, dated 25/10/2019, passed by so-and-so in case number so-and-so, PE number so-and-so. They were declaring the petitioner to be a foreigner post 25/3, 1971. Next, the learned counsel for the petitioner has referred to annexure 22, 20, XX 20 and 21, XXI of the writ petition to project that in respect of the said opinion dated 25/10/2019, the petitioner had filed a review petition before the Foreigners Tribunal number 11th, Barpeta at Sarvog, which was registered as miss case number 01/2549/2024, dated 27/12/2024. And it is submitted that the learned tribunal examined the said miss case on 18/11/2024, 28/11/2024, and 27/12/2024, and thereafter passed an order on 6/1/2025 to the effect that the examination, the study of the case in more details is required. And accordingly, the case was switched on 24/3/2024.
Actually, it was 2025, Lordship, 24/3.
2025. Okay.
Yes, Lordship.
24/3/2025. However, the said learned tribunal returned the said miss case number 01/2549/2024 to the learned counsel for the petitioner without, to the petitioner, not the learned counsel, to the petitioner without passing any order. First off,
It's with review petition in separate order,
huh?
page 90, Lordship. S3A, Lordship sees it's a handwritten,
Which page?
page 90, Lordship.
90. Yes,
Deals with review petition in separate order. And I'm not sure what exactly this means, Lordship.
separate order means, I did not get it. Please repeat again.
Lordship, I had this written, there's a nothing on this side, Lordship.
Left side, yes.
I think if she means section 3A or S3A, I have no clue what it is.
No, it says section 3A.
Yeah.
This is written, section 3A deals with review petition in
Separate.
ex parte order. Not separate, it is ex parte.
Lordship.
Down below, you'll find the same, you'll find the expression down below.
Down below, it is striked out. Section 3A2 deals with procedure for setting aside ex parte order, review petition filed for. After this note, the tribunal thought it could not deal with it, and therefore best thing is to return.
Lordship may, instead of granting bail, Lordship may just order no deportation, Lordship. He may not be deported, Lordship.
No, but you see, some sort of bona fide is there.
Lordship.
Some bona fide is there. It could have been rejected there and then, and
Lordship, leaving aside the review petition, if Lordship goes only by the opinion, then she would never have got bail. It would have been no deportation for the.
no, that's something else. But now we're showing a procedural lapse, and we since we are examining it.
Also, it would have been rejected because.
No, that is something else. Then we would have not entertained. But now he's projecting something which has to be addressed.
Lordship may take up, it's a very serious issue, Lordship, it's totally unacceptable.
No, but under the circumstances, we are inclined to grant bail. Issue notice returnable on give a date after 6 weeks. give a date after, after the, after the puja vacation, returnable on.
I think
No, not
13.
opening.
17
Complete 17.
17 of
17, 10, 2025. Extra copies of the writ petition to be provided to the learned CGC, State and Departmental Council by 2/9/2025, along with a soft copy of the writ petition. Next paragraph. It may be mentioned that when the learned counsel for the petitioner was asked to substantiate the correctness of annexure 22, 22, XX 20 and 21 of the writ petition, he has produced the a copy of the review petition within bracket annexure Roman 20, which contains the seal and signature of the learned tribunal, a learned member of the concerned foreigners tribunal number 11th, Borpeta Sarvog. Including rough notes made by the learned tribunal on the body of the petition, first off, we also note that the certified true copy of the order within bracket annexure 20, Roman 21, right, contains the original seal of the tribunal. In respect of the order dated 6/1/2025. Stop. Therefore, prima facie, the court records its satisfaction that review petition was filed by the petitioner before the learned tribunal, which was taken up on few dates and thereafter returned without any endorsement on the review petition as to the reasons why the review petition was returned. Next paragraph. In view of the nature of, in view of the manner in which the proceedings of a review petition was taken up by the learned member, foreigners tribunal number 11th, Borpeta Sarvog, the court is inclined to direct the Secretary to the Government of Assam, Home Department, Home and Political within bracket B, bracket close department, to take note of the nature, the manner in which the proceedings are taken up by the foreigners tribunal, and to examine if any administrative and if any order in the administrative side can be passed. Direct that the to direct the manner in which the tribunals would accept petitions and petitions filed before it, and the manner in which the and to also examine if there is any provision in the foreigners within bracket tribunals bracket close order, 1964 to return a petition filed by the proceedee and to prepare to pass appropriate directions as the said authority may deem fit and proper. Next para. As the proceedings before the foreigners tribunal are required to prove their citizenship. The burden of proof is lies on them. The manner in which the present proceedings was taken up by the concerned tribunal is required to be taken up by the appropriate bench dealing with the infrastructure issues of the foreigners tribunal. So therefore, the next paragraph, therefore, the matter, the notice of the registrar within bracket judicial be drawn to the disorder. Next paragraph. The registry shall call for the records from the concerned tribunal by email to the following email address of the learned tribunal. So the learned tribunal shall ensure that the original records be transmitted to the court forthwith without any delay. Stop. The said tribunal shall ensure that the superintendent of the tribunal shall also send photocopy of the cause list of the said learned tribunal on for the following dates: 18/11/2024, 28/11/2024, 27/12/2024, 6/1/2025, and 24/3/2024, and all other subsequent dates on which the proceedings of Miss case number 2549/17 was taken up. Next paragraph, the prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that there was an inordinate delay in preferring a review petition against the opinion dated 25/10/2019, which would otherwise was liable to be dismissed, having not been filed within the time prescribed by order (3) A within bracket 2 of the Foreigners Tribunals Order 1964. It is submitted that the said miscase was only an eyewash in order to create a cause of action to approach this court. Next paragraph. We take cognizance of the submissions made by the learned standing counsel for the FT matters. However, having noted that the learned foreigners tribunal had returned the petition without any adjudication in a manner which is hitherto unknown under the foreigners within bracket tribunals bracket close order, 1964. The same is found to be a good reason for the court to allow the petitioner, namely so and so, on bail, 10 days time to take bail out of this 5,000. to the satisfaction of Superintendent of Police Board of Barpeta. Next para, list on so and so. All those conditions would be there already. Turning on this document.
But can I have a copy of this order?
Yes,
today?
yes, yes, you'll get it. You will get it.
Item 15.
Subject, of course, to our certain disabilities of having been able to sign it. You see, our problem is multiplied by the fact that at 1:15 we have a meeting. 4:45 we have another meeting. And by the time we start our process of examining the orders and all. Yeah,
If possible, Lord.
yeah,
Because
yes, yes, I understand. We'll try to give.
the private
I'll try to give it.
department. law.
Just. Type it in priority, huh? This order, type in priority.
एक question. पूरे कोटी आपकी एक question.
हाँ?
एक question, सिर्फ आपकी एक question.
आज मैं सारा दिन your father finally reached home well.
Yeah. 2 hours of waiting.
It happened to me many years back when my daughter was in Sanskrit, the BSc. Was
He's
all you
now
can say.
74.
How do you allow me to go like this?
His work.
But we
इसको एक एक
weather focus देखने निकलने बोले.
लेके गया था. I mean, no. यहाँ भी होता है, यहाँ अलग तरह दिन बाहर.
Such me.
क्या फायदा इतना कंस्ट्रक्शन का, इतना डेवलपमेंट का.
तुमने एकदम ठीक लिखा था. Development, no, you will never be remembered. Itu suatu mahasiswa. Kita tak suatu sodi lagi.
My lord, impugned order page 41, my lord.
Still have to wait.
My lord. As your lordship wish. The date may be fixed, my lord.
You are Mr.
E.W. Aman.
Heard Mr. A.W. Aman and the counsel for the petitioner also heard respondents. The opinion rendered on 37/2024 by the Foreigners Tribunal Assam 11th Borpeta page 41 হলো নেব, has been essayed in this writ petition. Issue notice returnable 15th October 2025
Can it be before vacation, my lord?
sometime. You will not be deported.
My lord, I should not be arrested also.
Since the respondents are represented, formal notices are dispensed with. Extra copies within 3 working days
My lord.
from today. Call for the DCR to email also. Prayer for bail will be considered on the next returnable date. However, if the petitioner is apprehended in the meantime, she shall not be deported without further orders of this court. Petitioner will appear before the Superintendent of Police, Borpeta, Assam, with a certified copy of this order to bring it to his notice. List on 15th October along with PCR.
Your father is alive or deceased? Your father is alive or not?
My lord. I think he's dead, my lord.
He's
Not-
dead. Page 30, it is 2010. Yes. Correct.
My lord. Yes, my lord.
Item 16.
Impugned order, my lord, page number 26, my lord. Page 26. My lord. Next one, I should be happy, my lord. Next one is within time, my lord. Within the time.
Mr. Sharma. Mr. Sharma,
File.
in this case, how do you come to page 26? How do you read this line? Mr. I mean, page 26. This after the name of the court, FT case number so and so. Now there are 4 numbers. How do we read this in conjunction? FT case number so and so, reference case FT case number so and so. Is it like that? No, I understand. Number 1 is FT case number. What is the corresponding case? Is it in the right side?
The FT case number
2018.
And- So first line will be the connecting.
This lodge.
First line would be the connecting. Huh? Okay, there are 4 numbers, but there are 2 in fact. Huh? 1 and 2 I am writing. Page 26. So and so, reference case I2. So and so, entity case, reference case.
Should be the one below 56.
Okay. We have to explain. Okay. So I'm writing like that only. One is the first line is the first number and the reference number. Okay.
Explain with the next paragraph.
No. You see, we don't have, when we are correcting it, we don't have that much of time. So therefore I'm asking because in earlier orders, maybe perhaps we have made a mistake in making the reference numbers.
17.
Lordship, this, then it would be registered and read as case number 56 of 2018. FT case number 56 of Lordship, page 27, second paragraph. Subsequently, so and so jurisdictional rights, because the FTs were again.
No, that we understand, but the reference number would be serial number 1, left side and right side.
Yes.
Unless I explain it to them, they will make mistake in the typing.
Impugned order, page 40.
Lordship, we missed the bus by 1 day.
No, my lord, we filed it within time, my lord. 12th of August. 40, my lord. 21/8, my lord, impugned order.
Lordship. Just missed.
No, we filed it on 12.
It's when it's listed.
No, it's not when we file it, I think.
Ask Lordship. Lordship, if he is given that liberty, Lordship will have to give liberty to all the other matters also.
Generally, I think when it is filed, my lord, so we filed it with, well within 1 year, my lord. Maybe protected, my lord.
It's fine. It's when it's listed.
Heard Mr. A.W. Aman. Counsel for the petitioner, also heard respondents.
See next time.
The present writ petition under Article 226 of the Constitution of India has been filed. Assailing the opinion dated 21/8/2024. Page 40.
Utilize and don't do so. Ask.
Noted.
Issue notice. Returnable 4 weeks. Since the respondents are represented, formal notices are dispensed with. However, extra copies within a period of 3 working days from today. Heard on the prayer for bail, interim bail. Learned counsel appearing for the respondents opposes the same. However, in view of the projection made in the writ petition, we are inclined to grant bail. Petitioner shall appear before the superintendent of police.
South Salmara Mankachan.
Superintendent of police border, South Salmara Mankacha, Assam. Failure to appear within the time specified, bail shall stand against. Call for the trial court records. List on.
Grateful, my lord.
After receipt of trial court.
Grateful.
18.
Next. Lordship in this matter lordship.
Happy George, my impugnator is page 40.
Diction lordship. This copy is not at all legible. The opinion of the but you're not annexed to our petition.
After, if there was an objection, after that we have filed and submitted it.
The copy of.
Yeah, actually, type copy was given after the objection by the filing section, my lord. That is why it was not prevented.
But what is your explanation of delay?
My lord, in para 14, my lord, we have stated.
Para?
14, my lord.
Oh, that is something we will not accept. Ill health is somebody. It is something which is not acceptable.
One more for keeping it. What the others?
These are tragedies for which we have no answer. There are 3 petitioners,
Yes, ma'am.
all 3 of them ill together.
But mainly, my lord, financial hardship, my lord.
No, that's okay. We can't help it. These are tragedies of life. We are sorry, this is not acceptable. We are dismissing it. But Mr. I. Chaudhary, Land Counsel for the petitioner. Also heard so for the respondents. By filing this writ petition on Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 28/1/2019, passed by so-and-so in so-and-so page 48, type copy. So-and-so in FT case number so-and-so, police reference case number so-and-so, thereby declaring the three petitioners herein to be foreigner of post 25/3/1971. The issues of notice in this writ petition is opposed by the United Standing Council for the FT matters on the ground that the delay and latches in assailing the order is not is vague. Next. On the query of the court as to explain the delay and latches in assailing the impugn opinion, the learned counsel for the petitioner has referred to statement made in paragraph 14 and 15 of the writ petition. And it is submitted that the petitioners could not challenge the impugn opinion due to ill health and financial hardship. And the certified copy of the opinion could only be collected on 16/6/2025. So it is submitted that due to the fault of the learned counsel for the petitioners, the petitioners had failed to submit any documents of citizenship, and no statement was made with regard to petitioner numbers 2 and 3 in the written statement. Next paragraph. Having perused the material available on record, it is seen that the petitioners have, that though there are 3 petitioners, no documents have been annexed to show the nature of illness by which all the 3 petitioners were suffering from 2019 i.e. for 6 years. So moreover, there is no statement in this writ petition to show that the petitioners had provided all the requisite instructions to their learned counsel. But there was no pleadings in the writ petition. In terms of their instructions. Under such circumstances, on the basis of the vague explanation tendered in paragraph 14 and 15 of the writ petition, to substantiate that the 3 petitioners were all ill, and that they had signed the moreover, having filed the written statement on 13/7/2018. The petitioners had sufficient time to peruse the written statement before opinion was rendered on 28/1/2019. So accordingly, the allegation against the learned counsel for the petitioners of being vague cannot be accepted. Next, in view of an ordered delay and latches on part of the petitioner to assail the impugn opinion, on the ground of delay and latches alone, present date petition stands dismissed. Next, the registry shall transmit a copy of this order to the learned member from a foreigners tribunal number 4 from Morigaon. Make it a record of FT case number 56 of 2017 for future reference. Yeah. Advocate General, Additional Advocate General is here.
In respect of item number 23, my lord, I think my lord counsel for the appellant is also here, my lord. I want only one the time, my lord. May kindly be taken up tomorrow, my lord.
Sir Sharma was opposing it.
My lord. I am for the state, my lord.
Okay.
In the morning, I paid for upgrade, my lord.
Yes.
If possible, at 2, my lord. If
Today, my lord, I have difficulty. That is why, my lord. Only tomorrow, my lord, no problem. My lord.
No, tomorrow we have a special bench. We'll take it up day after tomorrow.
Yes, they have to also no problem.
As per my instruction, the private respondent has been visiting the deputy commissioner as well as the SDO civil for payment. It is regarding compensation of land acquisition. So that is why
I'll satisfy your lordship on the day after tomorrow, my lord.
if private respondent assured that they won't be going for the payment, then I think I have no problem.
I think, my lord,
Just a moment.
till Wednesday, nothing will happen.
Any dispute regarding appellant and the private respondent? Who would get the payment?
The land claims to be,
No, just a moment.
yes.
So Goswami just passed on instructions that they will not release the payment till day after tomorrow.
They have to, certainly, my lord, nothing will happen, my lord.
It's okay.
Till that, my lord.
No, but please please give them instructions not to
Yes,
disburse.
yes.
Otherwise, when we adjourn the matter at your request,
Yes,
payment is made.
Because I could not come to the prepared, my lord, that is.
No, it's okay, but
Fine.
see
Yes,
that they have
yes.
the instructions not to make payments.
And I believe, my lord, till Wednesday, nothing will happen, my lord.
No, we don't know. We
Right.
don't know.
Because they are also insisting the district administration.
No,
not
we
to
don't
go
know.
further.
We won't say anything.
Yes, yes.
Since you don't have knowledge, you don't
My bad.
comment.
Right.
This is procedure represented on the prayer made by Mr. B. Goswami, under the Additional Advocate General. The matter stands adjourned today. List on Friday, Wednesday. List on 3/9/20.
Obliged.
Tomorrow we have few fixed matters.
Right.
We'll continue because I have a meeting right now.
My lord,
At 2 o'clock, we'll continue. I have to.
only 37, my lord. My lord, 37 may be taken up on Thursday, my lord, because I'm not well, my lord. Item 37,
Tell the court master.
my lord. Obliged, my lord. Thank you.
দাদা অৰ্ডাৰ মাতিব নিদিয়ে মানে এডমিশ্যনৰ আগতে মাতিবনে
Next Monday, Louis, 8-9. নতুন নামতে চলাই
এইবিলাক নিমাই থওঁ নেকি হয় নেকি অ চাউণ্ডটো আহি যায় হেল্ল' হেল্ল' চাউণ্ড আহিছে না ঠিকে আছে
Hello.
yes
My second ground is that the detaining authority has not taken into account the fact that the petitioners were in bail when the detention order was given effect to. My lord, I would also argue on the condition that a detaining authority need to satisfy when a detention order is issued with regard to a man who is already in custody.
Yes.
My lord, I will also demonstrate that this detention order, the purpose of this detention order is other than what is contemplated under the P10 Act.
Yes.
And also, my lord, that the detention authority has not taken into account the effectiveness of the bail condition, whether the bail conditions are sufficient to deal with stopping the petitioner from indulging in whatever, my lord, allegations, indulging in prejudicial activities pertaining to narcotic and psychotropic substance. Effectiveness of bail condition, because, my lord, recently there is a judgment, my lord, of the Supreme Court which says this has to be, the detention order have to consider. Now, my lord, by first ground of argument, my lord, I'll just give certain dates. My lord, the petitioner was initially arrested on 2/1/2024. 2/1/2024, the petitioner was initially arrested in connection with NCB crime number 17/23. 17/23 on 2/1, 2nd of January 2024, he was initially arrested. The very next day, on 3/1/2024, he was shown arrested in connection with NCB crime number 18/23. It is these two cases, his implication in these two cases, which had culminated into issuance of this detention order. Now, my lord, the detention order was issued on 13/5/2025. Though not served to the petitioner. Now, my lord, on 14/5/2025, the petitioner was granted bail in connection with the first case, NCB case number 17/23.
But factually you are wrong.
My lord,
Come to page 40. Actually, your submission is wrong.
I'm sorry, my lord. It's possible.
Page 40, this vital fact was not considered before handing over with the order of 13/5/2025 on so and so. So 28/5 you were served.
My lord, page 40.
Yes.
In the instant case, I was in fact shown arrested on 3/1/2020.
First line of page 40.
This vital fact was not considered before handing me over the order dated 28/5/2025.
Yes.
Yes, because the order was served on the petitioner on 28/5, that is after 15 days from the date of issuance of the order.
That means you were not available in your address.
My lord, I am in custody. I am in central jail.
No, your second submission was the petitioner was on bail when the detention order was given effect to.
No, my lord, my second submission is that my bail order was not considered before.
No, that is your third submission. Effective of the bail condition is your third submission.
No, my
Your
lord.
first submission was that no live and this link with the
Yes.
with the grounds of detention. Second, you said petitioner was on bail when detention order was given effect to.
He was granted bail. He did not come out. The bail order was passed prior to the day when the detention order was handed over to him. This fact was not, my lord, the detaining authority have not been informed by the sponsoring authority. So, my lord, on 13/5/2025, detention order issued but not served. Now, my lord, on 14/5/2025, bail granted in NCB case number 17/23. That is the first case. Now, my lord, on 16/5/2025, My lord will kindly come to page number 37. The second bail application came up for hearing before this court, page 37. My lord is there at page 37. Now, my lord, on 16/5/2025, the second bail application, when it came for hearing, what was the submission made from the NCB? My lord will kindly see at page 38. The Learned Standing Council NCB prays for some time to produce recent central government notification in connection with this case, which is allowed. Now, here they are speaking about the detention order. They make a submission much before the date when it was handed over to me. It was put into effect. And accordingly, the matter was fixed on 21/5/2025. Now, my lord, on 21/5/2025, when the matter was finally heard, the NCB made a submission that I am already arrested in connection with this PT NDPS Act, which your lordship will find at page number 23. That is the final order of bail, because on 21, the bail application was heard and it was fixed on 28 for delivery of orders. 28 order is at page 23. There is the second bail, order granting the second bail. 23 is this order, my lord, which was delivered on 28. Argument was concluded on 21. My lord will kindly come to page 25, para number 7. According to Learned NCB Council, the accused petitioner number 2, Yusuf Ali, has been indulged in organizing illicit trafficking, narcotic drugs and substance, as well as high propensity to engage in illicit activity. He was arrested under section 3(1) of Prevention of Illicit. So, my lord, on this day, on 28, that is on 21, the order is on 28, it is on 21. They submitted those detention orders before this court. And a submission was made that I am already arrested, which is wrong. Because this detention order was handed over to me on this very day when I got bail on the second, on 28/5/2025. My lord will kindly see the detention order, which is just page number 30. Page 30, my lord will see. These detention order, along with the grounds of detention, page number 31, my lord may see, page 30 is the order. The grounds, these are at page 31. Page 31, my lord may kindly see. It is dated 13th of May 2025. And down below, my lord will see, it was received on 28/5/2025. That means the day when he got bail in the second bail, second case, my lord. Therefore, my lord, this order was in fact issued to oppose my bail, not to prevent me from indulging in all this. Now, my lord will kindly see, if your lordship takes up their affidavit, the affidavit filed by the central government, my lord, page number 69, running page 69, para 7. They say that they have initiated the procedure of issuing this detention order in the month of January, 2025, central government. page 69, para 7. My lord is there at page 7?
Paragraph?
7, their affidavit, central government's affidavit, running page 69. Maybe some pagination here and there, my lord. But paragraph is 7. Affidavit filed by petitioner, respondent number.
File on, my lord, 26/8, my lord. It's on record.
By.
Filed by respondent number 1 to 3, my lord.
By.
By, my lord, Bhagavan Sahi Mina.
Paragraph 7, page 63.
Oh, my lord.
Page from 55, my lord.
No, I don't.
Para 7,
Para 7 section 7.
63, you know, no,
There is an additional affidavit in between.
That have.
Para 7, page 63. 63 hours. 69, no.
Yes.
You tell us.
Now, my lord, they say that the procedure for detention order was followed since January 2025. So the procedure started in the month of January and the detention order was issued in the month of May. There is an inordinate delay of 5 months from the day when the detention, when the sponsoring authority referred it to the detaining authority, and finally the date when the detention order was issued. Therefore, my lord, there is no proximate link my lord has seen that, my lord. So eventually it took 5 months, unexplained delay of 5 months as to why they took 5 months to issue this detention order. Now 5 months to issue and another 15 days to serve it on me. And during this period of 15 days, the two most vital development was I was granted bail between this period.
What happened to that NCB 18?
18 is the bail order or 28. On
And
20,
There was another case. where
yes,
it showed-
that I got bail at page number 18. That is on 14/5.
Was- You were shown arrest in which case?
I was shown arrested in NCB crime number 18/23.
And
I was initially arrested NCB crime number 17/23
so you got bail in NCB 18.
on
14/5.
on 14/5.
NCB 17.
That is on 16, on 28. That is page number 23.
28 is some other NCB crime.
No. These are the only two NCB crime numbers.
I'm sorry.
So they somehow wanted to, my lord, oppose my bail. They wanted to get my bail cancelled. Now, my lord, it is not explained anywhere as to why they took these 15 long days to serve a copy.
Just tell us how many, what is the quantity of the drugs seized in all these two cases?
My lord, that I'll have to. Because nothing was recovered from the possession of the petitioner. However, my lord, the quantity involved is in NCB 17, it is 0.457 kg of heroin. It kg লিখেছো গ্রাম হবো তো এই গ্রাম না কেজি আপনারা ভেরিফাই করছেন যাতে দেখুন কেজি লিখেছো
It will be kg.
kg
It's always
yes
kg.
gram a kg and it was recovered from the possession of one Shahid Alam, Farooq Khan, Amir Khan and Habibur Rahman, not from the possession of the present petitioner. Your lordship will find it at page 83. And in NCB 18/23, the total
Yes.
my lord, should I say the quantity in the next case?
Oh, we have it 409 kg.
Yes,
Point-
but in the second case also, nothing was recovered from the possession of the present petitioner based on 67 statement. That is in perimeter with 161 as held by the apex court in Preventive. Now, my lord, therefore, my lord, my submission here is that the delay of 5 months snaps the link. That is the live and proximate link. And in this regard, my lord, I'd like to rely on 2022. I'll give a copy, my lord. Here also, my lord, identical. In this case also, the detaining authority took 5 long months to issue the detention order from the date it was sent to the detaining authority by the sponsoring authority. Here, the sponsoring authority is the NCB. NCB will refer it to the central government detaining authority. In this case, similar identical, my lord, 5 long months, and which was a fact considered by the apex court and which would vitiate the detention order. I'll mark the para, my lord. Para is paragraph 6, 11, 12, 13. My lord, para 6. In para 6, your lordship will see the petitioner in that case was also arrested in connection with 2 cases. And in both the cases, he got bail. And the Supreme Court, para 6, last line. However, what is important to note is that in both the aforesaid cases registered under the NDPS Act, the appellant herein was ordered to be released on bail by the Special Court Tripura. Now, because this fact was not considered. Now, my lord, paragraph 11, my lord. Para 11, yes. Para 11. We are persuaded to allow this appeal on the following two grounds. Number one, delay in passing the order of detention from the date of the proposal, thereby snapping the live and proximate link between the prejudicial activity and the purpose of the detention, and the failure on the part of the detaining authority in explaining such delay in any manner. And in this case also, my lord, the delay was exactly 5 months. And the other is the detaining authority remain oblivious of the fact that in both the criminal cases relied upon by the detaining authority for the purpose of passing the order of detention, the appellant detainee was ordered to be released on bail by the special court. The detaining authority remained oblivious as this material and vital fact of the appellant detainee being released on bail in both the cases was suppressed, or rather not brought to the notice of the detaining authority by the sponsoring authority at the time of forwarding the proposal to PASR. Now, there is a little difference in my case. In my case, on the date when the detention order was passed, I was not on bail. But on the day when it was given effect to, on 28, I was on bail. So before it was given effect to, they could have placed it before, informed the detaining authority about the new development, since it was not served upon me. Now, my lord, a question might arise that from Delhi, this order will take some time to be served in, my lord, Guwahati. My lord will see their additional affidavit last annexure, because my detention is now extended for 1 year. On the same day when it was issued in Delhi, on the same day it was served in Guwahati, the extension order. That fortifies, my lord, that there cannot be any other logistical issue in delivering it. Their additional affidavit, the last page is the order whereby it was extended. I've seen, my lord may see the last page is the page number does not tell you. So therefore I'm saying the last page. 85 page number. Your lordship will see this is the order whereby by 3 months, initially I was detained for 3 months. It was extended by 1 year. It was issued on 28/7 on the left hand side. I signed it on 28/7 on the same day. Yes, my lord, the judgment which I was reading. Now, para 12, delay in passing the order of detention. My lord, I'll skip the factual narration just to show the, my lord, similarity of fact. My lord, kindly see para 12, the last line. There is no explanation worth the name why it took almost 5 months for the detaining authority to pass the order of preventive detention. Then, my lord, para 13, while the Supreme Court quoting another judgment of the Honorable Apex Court, it says, preventive detention is devised to afford protection to society. The object is not to punish a man for having done something, but to intercept before he does it and to prevent him from doing so. Para 15, my lord. The adverse effect of delay in arresting a detainee has been examined by this court in a series of decisions, and this court has laid down the rule in clear terms that an unreasonable and unexplained delay in securing a detainee and detaining him vitiates the detention order. In the decisions we shall refer hereinafter, there was a delay in arresting the detainee after the date of passing of the order of detention. Now, my lord. However, the same principle would apply even in the case of delay in passing the order of detention from the date of the proposal. The common underlying principle in both the situation would be live and proximate link between the grounds of detention and the avowed purpose of detention. That the delay in passing the detention order would vitiate the detention order. Para 21, my lord. It is manifestly clear from a prospectus of the above decision of this court that the underlying principle is that if there is an unreasonable delay between the date of the order of detention and actual arrest of the detainee, and in the same manner, from the date of the proposal and passing of the order of detention, such delay unless satisfactorily explained throws a considerable doubt on the genuineness of the order and consequently render the detention order bad and invalid because the live and proximate link between the grounds of detention and the purpose of detention is snapped in arresting the detainee. Now, in this case, my lord, there was a certain vital fact which was not brought to the notice of the detaining authority by the sponsoring authority with regard to his bail applications. And in that regard, I will press para 23, vital material fact or vital fact withheld and not placed by the sponsoring authority before the detaining authority. Para 23. Para 23, para 27, because the bail issue was not considered. Para 27, para 28, para 27, 28, 29. Para 29, finally, the preventive detention is a serious invasion of personal liberty and the normal methods open to a person charged with commission of any offense to dispose the charge or to prove his innocence at the trial are not available to the person preventively detained. And therefore, in prevention detention jurisprudence, whatever little safeguards the Constitution and the enactments authorizing such detention provide assumes utmost importance and must be strictly adhered to. Now, my lord, will kindly come to page number, the detention order, page, yes, page number 32 and 30, 32 first and then 34, page number 32. What was the information given to the detaining authority, my lord will see, by the sponsoring authority? My lord is there at page 32. My lord, there are small paragraph alphabetically. Kindly come to para J, small j. Bail application of Yusuf Ali, that is you, was rejected by the trial court on 14/3/24. Thereafter, the bail application was rejected by the Guwahati High Court on 2/5/2024. I take a pause here, my lord. This is a wrong fact. Now, I'll show, my lord, what order was passed by the learned, by this honorable court on 2/5/2024. My lord will find that order at page number 51. In fact, my lord, when he first approached this honorable court by way of a bail application during investigation, during pendency of the bail application, they filed the charge sheet. So a submission was made when it came up for hearing. A submission was made, the charge sheet was filed. In view of that submission, the bail was disposed of with a direction that he is at liberty to go and approach before the court below by filing an appropriate application, which will be considered in accordance with law. There was no as such rejection of his bail prayer, which your lordship will gather at page number 53. That order of 2/5, which they are saying that it is rejected. Wrong facts were informed to the detaining authority, which is also a ground for assailing a detention order. Similarly, my lord, this is with regard to NCB crime number 17. Similarly, my lord, with regard to NCB crime number 18, my lord will kindly come to page 34, similar alphabetical paragraphs.
Mr. Biswas, there was a fresh bail application filed before the High Court on 11/4/2025. Till that, they knew,
Yes,
and before that bail was disposed of, they passed the detention order.
no, detention, see,
It came on 13/5.
I'll explain it in
The
this way.
detention order came on 13/5.
13/5,
The bail was granted on 14/5.
14/5.
So as on the date of passing of that order of
Order.
detention, the second line of the paragraph that you were reading, subsequently a fresh bail application was filed again before the High Court on 11/4/2025, which is pending before the Honorable Court. Was it correct?
Yes.
As on 13/5.
Yes. I'm on the fact that they say that on 2/5, my bail was rejected by the Honorable High Court.
That part is wrong.
My humble submission is that part is wrong, because no bail was rejected. Similarly, at page 34, with regard to NCB crime number 18, they again wrongly informed the detaining authority. Page 34, alphabetical paragraph M, small m. That is with regard to the next case, because there are two cases. Page 32 is NCB 17, this is NCB 18. Here also they say that Yusuf Ali, you filed a bail application before the Honorable High Court, which was rejected. This was also not rejected. The order is at page number 53. Similar direction, because during pendency of this bail application, charge sheet was filed. Same day. Two applications, they were moved together. In between, charge sheet was filed, and my lord, normally, my lord, such orders are passed when charge sheets are filed, because the records are before the trial court, and therefore. Now, my lord, coming to my next limb of argument, that what condition the detaining authority need to satisfy before passing a detention order with respect to a man who is already in custody. My lord, when I was trying to, my lord, I could lay my hands on one judgment of 1990. I'll come to that judgment, because that is the first judgment in this regard. 2-3 judgments are rely, my lord. In substance, what the Supreme Court says is this, my lord, that two conditions has to be satisfied. Condition 1 is the detaining authority must know that the person is in custody, which the condition is satisfied in this case. Coming to the second condition. Second condition says the detaining authority must know there should be cogent material before the detaining authority to make an opinion that there is a likelihood of he being released on bail in near future. That there is a likelihood of he being released on bail on near future. If your lordship is holding that 1990 judgment, then para 21, my lord will say. And my lord, as recent as 2025, this judgment is being uniformly followed, my lord, in cases when detention order is passed with regard to person already in custody. The decision, my lord, may I read it, my lord? The decision referred to above lead to the conclusion.
Just tell us, because it will consume time reading. Just tell us what is there.
Yes, my lord, the two conditions, that what I said, my lord, exactly. That the detaining authority was aware of the fact that the detainee is already in detention. This is condition 1, which is satisfied in this case. I am on condition 2. There were compelling reasons justifying such detention despite the fact that the detainee is already in detention. The expression compelling reason in the context of making an order for detention of a person already in custody implies that there must be cogent material before the detaining authority on the basis of which it may be satisfied that the detainee is likely to be released from custody in near future. But there must be some cogent material. Because otherwise, my lord, if a person is in detention, there is no point issuing a detention order. So, cogent materials to make an opinion that he'll be released on bail. This next to judgment consequence. Better possibility. Amritlal and others versus Union of India, 2001, Volume 1, SCC, 341, para 4 and 6. Yes, ma'am. Yes. The penultimate paragraph. I'll come to that. My lord, I'll come to that. I'm cognizant of that. My lord, then I'll straight away answer your lordship's query. That in the penultimate paragraph of page 34, they say that my likelihood, what is the cogent material with them? That since there is no direct recovery from me, therefore, I may be granted, there is a likelihood that I will be granted. My lord, with all humility, my lord, whether direct recovery is required in an NDPS case, Mohit Agarwal, there is a judgment, Mohit Agarwal, your lordship, because your lordship has also passed quite a number of bail orders where Mohit Agarwal was quoted. In Mohit Agarwal, the Supreme Court has clearly said that possession is not required to implicate a man under the NDPS Act. And this is commercial quantity, my lord. So commercial quantity, section 37 immediately comes. A satisfaction has to be formed regarding my innocence with a additional condition that after granting of bail, I will not commit similar offense. So with all these conditions, my lord, only because there is no direct recovery, it is no cogent material. It is no cogent material to come to a conclusion that I'll be granted, that I'll be released on bail. In fact, my bail was not even, all these points were not even discussed while granting bail. My bail was squarely for violation of Article 22, Sub-Article 2. No ground of arrest was intimated to me. And in view of that, Prabir Prukaisto, Pankaj Bansal and Vehan Kumar. So that my argument against that page 34 is that, page 34, that observation is that only because there is no direct recovery, that is no cogent material, especially in a case of commercial quantity, where the rigors of section 37 is applied. Now, yes, my lord, the judgment which I was referring to, that 2001. 2001 वाला कहाँ है? जो हो गया उसको बताओ. Para 4 and para 5. Sorry, para 4 and para 6. In Augustine decision, this court also placed strong reliance on the earlier but off-cited decision in the court of I'll skip all these things. The court held that there must be a cogent material. The court held that there must be cogent material before the officer passing the detention order that the detainee is likely to be released on bail. The inference must be drawn from the available materials on record and must not be the ipsi dixit of the officer passing the order of detention. It is this perspective as above that the recording of the officer concerned in the matter under reference ought to be noticed, and the, I skip, para 6. the requirement as noticed above in such case that there is a likelihood of the petitioners being released on bail, however, is not available in the reasoning as provided by the officer concerned. The reasoning available is the likelihood of his moving an application for bail, which is different from likelihood to be released on bail. This reasoning in that case, a reasoning was given that he will apply for bail. Supreme Court says that cannot be a cogent material to form an opinion that he will be released on bail. These are the two paragraphs of this case. And another two paragraphs of this 2012 judgment, my lord, this is very interesting. 2012 7 SCC. Para 9 and para 15. Para 9 and para 15. Para 9, in fact, reiterates para 9, my lord. Para 9 is reiteration of the same 1990 principle.
गुवाहाटी हाईकोर्ट का दोनों रेडी है
Now, my lord, in this case, in 2012, this judgment, what happened is that the satisfaction that he will be enlarged on bail was gathered from a fact that in similar cases, some other persons in similar type of cases got bail. Supreme Court says that cannot be a cogent material to come to such a conclusion, which your lordship will find at para 15, 1-5, internal page 187. My lord, my purpose of showing these paragraphs is that even the reasons which they cite to come to a conclusion that he will be likelihood of he being released on bail is also justiciable. My lord, may I proceed? Now, my lord, based on this line of argument, division bench of this honorable court had set aside the detention order based on similar grounds, my lord. I'll not read those, I'm just giving it for your lordships. These are the division bench orders of our High Court where all these judgments were referred, and finally, my lord, the detention order was set aside. In both these cases, they were found wanting on the second criteria, that is the satisfaction that he will be enlarged on bail. Paragraph number लोग देगा, para number लोग दे देता है. Para number, my lord, that Nancy versus State of Nagaland, para 15 to 20, and Gurmeet Singh, but that is para 23 to 25. The lordship may see one, that Gurmeet Singh judgment, if your lordship kindly sees, my lord will kindly see the opening, I mean the first para. The wonderful poem, or in fact a song, has been paraphrased, my lord. I read it again and again because it was so clear. Born free as the wild blows, as free as the grass grows, born free to follow your heart, born free, and beauty surrounds you. The world still astounds you each time you look at the star. Stay free, with no walls to hide you. You are as free as the roving tide. So there is no need to hide, born free, and life is worth living. It's only worth living if you are born free. In this case also, my lord, ultimately the detention order was set aside, but it started with a very interesting note. Yes, my lord. Now, my lord, that this detention order was in fact passed for purpose other than what is contemplated under the PIT and DPS Act. My lord, during the course of my argument, I have demonstrated, my lord, because this detention order was in fact placed before the court during a hearing of a bail application 7 days prior to the date when it was actually handed over to me, whether it is permissible, my lord. Kindly come to this. It is Amina Begum. My lord, this judgment, Amina Begum, my lord, this lays down the parameters. There are as many as 13, 14 grounds, parameters under which a preventive detention order can be challenged. Paragraph 28 is important, my lord. This lays down the parameters. And my lord, of late, whatever judgment has been rendered on preventive detention, all judgment have this judgment in common. This judgment is in common, I have seen. All courts are referring this judgment, para 28. Primarily because of this para 28. These are the parameters, my lord. In the circumstances of a given case, a constitutional court, when called upon to test the legality of orders of preventive detention, would be entitled to examine whether. These are the parameters. Now, my lord will kindly say, 28.3. My lord will say 28.3. Power has been exercised for achieving the purpose for which it has been conferred, or exercised for an improper purpose not authorized by the statute and is therefore ultra vires. Now, my lord, the purpose of issuing a detention order under PIT and DPS Act is preventive, is to prevent a person. It's not to oppose his bail application. And these are the parameters, my lord, under which a detention order can be challenged. And para 29 assumes importance because the Supreme Court says for violation of any one of these parameters would entail an, my lord, setting aside of the detention order. Kindly para 29. Should the court find the exercise of power to be bad and or ought to be vitiated, applying any of the tests noted above, rendering the detention order vulnerable, detention which undoubtedly visits the person detained with drastic consequence would call for being interdicted for righting the wrong. If the detention order is found wanting on any of these parameters. And same judgment, my lord, para 59, if your lordship kindly turns. Well, para 59 primarily says that when there is a alternative remedy available under the normal criminal law, for example, cancellation of bail and all, then in those circumstances, my lord, this draconian provision should not be otherwise resorted to. That's in my understanding, my lord. It is pertinent to note that in the 3 criminal proceeding, I'm reading this line, it is pertinent to note that in the 3 criminal proceeding where the detainee had been released on bail, no application for cancellation of bail had been moved by the state. In the light of the same, the provision of the Act, which is an extraordinary statute, should not have been resorted to when ordinary criminal law provides sufficient means to address the apprehension leading to the impugned detention order. There may have existed sufficient ground to appeal against the bail order, but the circumstance did not warrant the circumvention of the ordinary criminal procedure to resort to an extraordinary measure of law of preventive detention. Now, my lord, in my case, I can understand a situation of passing the detention order on 13 because on that day I was not on bail, but subsequently, the detention order was extended after my representation. And in my representation, I informed them that I am on bail. But still, my bail matter was not, my lord, considered. দাদা আপনাকে একটু দিয়ে দিছি এরপর আপনি চলেন দুটো গেটে আসছে
In your representation, where have you informed them?
Sir, representation, my lord will find at page number 39. 39, it starts, my lord. My lord will see page 40, point number 4.
Page number?
40. Page 45. Bail number also I have given, granted, date, everything given. This is for one case, and for the other case, NCB 18. Para 6, even their conduct also I have, my lord, that how this detention order was being used for a collateral purpose. Even then they extended this by another 1 year. Because my 3 months time has expired by now. Had it not been extended, my lord, by now this would have been infructuous. 25, 6, 7, 8, yes. Now, my lord. Now, my lord, this is a very recent judgment, my lord, 2025 SCC online. Dhania M versus State of Kerala. Dhania M versus State of Kerala. My lord, page para 20 and 21. Now, here is a new line of thought, my lord. Here, my lord, Supreme Court has said that if somebody is on bail, then the detention authority should examine the conditions of the bail. That whether the bail conditions are sufficient to carve the menace. That has to be considered para 20, my lord, will see. Moreover, it has been stated by the authority that the detainee is violating the condition of bail imposed by him in the case. However, pertinently, no application has been filed by the respondent state in any other four cases alleging violation of the in the court. Kitna tha paragraph 20 or 21. This court in SK Nasim had observed that the state should move for cancellation of bail of the detainee instead of placing him under the law of preventive detention, which is not the appropriate remedy. Similarly, there have been existed sufficient. कौन सा था वो बोला effectiveness of bail? तुम ये कहाँ से लिया है? वो live लेगा था ना? Well, it is there. Has been also the detainee is violating conditions. Observation में the detention. ये तो SCC से निकला है ना? I'll indicate the exact paragraph which says that the effectiveness of the condition of bail has to be considered by Justice Dhulia. This is by whom? No. और एक तो है. ये नहीं है. This Justice Dhulia. हाँ ये है Justice Dhulia का. Yes, this is the judgment. Huh? 32? Yes. My lord, the proposition which I was, my lord, it is in fact, it is in this case by Justice, this is 2025 4 SCC 476, this case. That the effectiveness of the condition of bail page 476. Thirty-two and 32, 34. ये बड़ा गलती कैसे बन गया? Yes. Yeah.
Just one correction.
Yes.
It is not Dhania, it is Dhanya.
Dhanya.
वो धन्य हो गया. Dhanya, not Dhania. Yes, you're referring to something.
Yes,
You-
this
you-
20, in fact, the judgment is 2025 4 SCC, this effectiveness of bail condition, 2025 4 SCC 476, para 32, 34, and 35. Now, this is something very new, my lord. Para 32, your lordship, sir. Likewise, in the present case, we are not concerned as to whether the condition imposed by the magistrate would have taken care of the apprehension expressed by the detaining authority of the detainee indulging in further smuggling activities. We are more concerned with the aspect that the detaining authority did not consider the efficacy of the conditions and enter any satisfaction, however subjective it is, as to the conditions not being sufficient to restrain the detainee from indulging in such activities. So the bail condition has to be considered.
The detention order is passed before the bail. How?
No. The second order is passed after the bail, extending the period for 1 year.
Not required. 3 months extension every time is not required. There is an order of the Supreme Court.
No, my lord, initially they can pass for 3 months, which can be under section 9 of the P10 DPSS can be extended for 1 year. Now they have passed, I'm not talking of period, they have passed one extension order for 1 year. So before passing that extension order, why this extension is required, my lord, some subjective satisfaction?
That's what we are saying. There's one judgment which says that extension order is not even required. It could have been passed for a year. In this case, it was not done, but that will not cause any dent in the.
Because my lord, my first, the detention order, it was only for a period of 3 months, which already expired. Now I am in detention on the strength of the extension order.
In this case, Joey Kitty, you are referring to paragraph 32.
32 and 34 and 35.
34, 35.
Now, my lord, with regard to, this is a 3-judge bench judgment of the Honorable Apex Court. This is on the point that I'm referring to para 32. Para 32 is the longest one, my lord. I'll take your lordship to internal page number 35. 1, 2, 3, 4, 5, 6, 7 line from bottom, which starts with "it is well settled."
Para 32 is there in that Amina Begum also. It is covered.
That, my lord, when a person is enlarged on bail by the competent criminal court, great caution should be exercised in scrutinizing the validity of an order of preventive detention.
You will find that in paragraph 60 of the
Amina.
Amina.
Yes. So
Not
this.
multiply judgments.
So, my lord, my point is that, my lord, since a caution, that because once a man is in bail, my lord, by a competent criminal court, my lord, great caution has to be taken. Now, in this case, my lord, at least before extending, they knew this fact of bail. So that should have persuaded them for not extending the same. Now, my lord, there has been a total delay of 18 days in disposing of the representation by the detaining authorities. My lord, I'll just give certain citations with para where 25 days, 14 days, 17 days, 20 days, 22 days, 19 days, 17 days delay were considered unreasonable, violative of Article 22. I'll just give that list of judgment. There is no, my lord, because your lordship is each and every judgment reading, my lord. I'll give the number of days, delay number of days, and the citation. The first one is 1981, 1 SCC. A list एक बार दे देना. I'll give that list. Because there are judgment where, my lord, 25 days delay was fatal. There is one judgment where 14 days delay was fatal, another 17 days, another 20 days, another 22 days, and 19 days, 17 days.
No 18 days.
17, 14 are there, man. Correct. I'll give a chart of that, my lord. Okay, sir. Even I have the copy of the judgment. I'll just give it, my lord. Your lordship may consider the same. दे दो. पैरा नंबर लिख देना. हाँ, delay of communities.
Yes, sir.
Okay. So, my lord, at the end of the day, my lord, preventive detention purpose is not punitive, my lord. It is preventive, my lord. And in this case, it seems that the detaining authority is trying to punish the petitioner for his previous conduct, my lord. And my lord, in both those cases, still the presumption of innocence runs in his favor, my lord. Because he is yet to be convicted in either of these two cases. That's all, my lord. I have to submit, my lord, subject to what they say.
There are many prayers for upgrading. But pick up your hearing on Thursday.
My lord.
Submissions of Mr. M. Viswas and counsel for the petitioner is concluded. The concluded comments reserving right to reply. In your positive time, the Learned CC and the learned standing also for the NCB shall be heard on the next date of listing, list on 4/9/2025.
And
Give a list of your books, this.
Yeah.
List and the paragraphs.
absolutely, madam. In fact, what I'll do is that I'll make a spiral binding, I'll give it.
Not required. We don't need all those things. Just give us a list and the paragraphs.
Absolutely. Absolutely.
No need to quote the paragraphs in whole. No need to quote the paragraphs in whole, just the paragraph number. Citation so and so, paragraph number so and so.
Upgraded item 26.
Live streaming, live streaming.
My lord. Father's name is recorded in page number 29, my lord, 1965 voter list. my lord.
Look at this opinion. Do you think this is correct? Page 26 onwards. For example, come to page 27. Look at exhibit H. Exhibit H is the passport issued in the name of so and so. As the claimed father of the so and so is already declared not foreigner, same is no way assess the OP to linkage with the claimed father. What does this mean?
Lordship, yes, Lordship. But I have go through the petition, Lordship. There was no such order we could find, Lordship, regarding he is not declared as foreigner, Lordship. Why this statement was,
We don't know, but once he is not a foreigner, then you will have to discuss the linkage.
So, my lord, the third paragraph, my lord, it is stated that, can I read, my lord?
Which one?
The third para in the same page.
Yes.
It says on close scrutiny of exhibit B, letter dated 22/12/2021 received from the election officer Nogao, and on perusal of exhibit C to G for its continuity, it is found that the claimed father of the OP, that is Abdul Rashid, was available into this territory of India prior to 25/3/1970, which is the cutoff date for identification of the Foreigners Act as per section 6. So the father's citizenship is
There is no question on that. It's only with regard to the linkage, my lord. And the linkage also, my lord, if I can take your lordship through the next 2-3 paragraphs.
Just a moment. And this finding at this we will first read you this page 57. Lal Muhammad, headmaster,
My lord.
cross-examination. It
My-
is not a fact that the father's name in serial number 18, exhibit A4 was entered later. The handwriting is also not identical.
Probably this is a continuation of the first sentence,
No, that's okay.
my lord.
See, come to page 27.
My lord.
In the middle, there are two exhibit A.
Hmm.
5 paragraphs from below. Exhibit A and evidence of DW2 cannot be accepted as a valid piece of evidence for more than one reason. Firstly, in admission register, the father's name and the OPR serial number was entered later on. Now, where is this finding?
Exactly, it could be demolished, my lord.
We are asking a question, don't give running commentaries. You are asking questions to him.
My lord, my apology.
Don't give running
My
commentaries.
apology, my lord.
Secondly, there was no resemblance of handwriting.
Where is the records? Is the records come?
I think the report has come.
File has been received. Reports. It's come. Oh, I'm sorry.
Lordship.
He does not ask any other question. No clarificatory question under 165.
Lordship.
Cross-examination, we have shown it to you. Now, there must be some override, there's some compelling reasons to say that this is a insertion. Handwriting is different.
Lordship.
If it is not there, you see what has happened here. Without any reference, the tribunal has declared his projected father as an Indian.
Yes, Lordship.
There was no reference.
Yes, Lordship.
And he was made declared to be an Indian.
Yes, Lordship.
Now, if somebody can connect him with this person, he will automatically become an Indian.
Lordship. Without any basis, Lordship.
It's the tribunal. Because once you reject once it is rejected, a valid cause must be shown. And in this opinion, it merely says that it cannot be accepted, this cannot be accepted, link that cannot be accepted. And we also fail to understand, you see, this DW3 was rejected because he could not produce any registered book.
Lordship.
Correct. Now, is there a requirement? You see, number one, this DW3, he's a government Gangura.
Yes, Lord.
Has the government provided him with any register to issue certificates? No, definitely no.
No, but Lordship, there is a settled law, Lordship, without record, Lordship.
No, but this was not rejected because of that.
Yes, Lordship.
You see, for this many years, every time a student come to us for internship, student internship, we give them a certificate.
Yes, Lord.
I sign and give it to them, saying that so and so of so and so college was attached to me for this many days.
Yes.
I always sign it. Now, can that somebody reject it, saying that the High Court did not issue it under register, it was not brought? Can that certificate be rejected just like that? But this could have, it was rejected on the ground that if use of state emblem,
Yes, Lord.
that is good enough, but why unnecessary? Yes, Mr. Aman, what do you have to say?
My lord, my humble submission is that there is no question about the citizenship status about the father. And as your lordship has rightly pointed out, there are two linkage documents, and one has been rejected because it says that the handwriting is not identical. But they could not demolish these questions were put to the DW2, the headmaster. And the headmaster has, in the cross-examination, has clearly stated, but that could not be demolished. So it stands, my lord. So there are two linkage document and both the authors appear before the learned tribunal.
Where is your written statement?
My lord, my written statement is page number
20.
20, my lord, yes.
Just give us the record for a finding.
My lord. Page number 48, my lord. 48. My lord.
In your written statement and in your evidence on affidavit, you have withhold your age. Why?
No, it is written when she was born, 1988, my lord. In evidence, my lord, is paragraph 6, that written that she was born in 1988.
1988.
My lord.
So, what would you say at this page 54? You are 40 years on in December 21.
My lord.
This brings your date of birth on 1981. Now come to your page 19. In 2025, you are 37 years. That makes you 1988.
My lord.
As per your school register, what was the date of birth?
88, my lord.
In school register, you don't give your date of birth.
Yes. My lord.
You are admitted in class 1 in their on 4194.
My lord, this,
Age 6 years.
yes, my lord, this certificate says 98 years honor Mahor, 31 তাৰিখত স্কুলত তেওঁৰ শিক্ষা শেষ হ'ল. So in 1998, she passed class 4.
So how many years in that school?
4 years, my lord.
No,
Can one be admitted in class 1? In a
minimum
junior
9
school?
years, lordship.
This is class.
During completion of his examination, he should.
I
Class
got to know,
4.
you see, because we studied on very old times in school. We had upper KG, lower KG, A, B, 1. That's why we are asking
In
you.
government schools, my lord, in lower primary schools, common, Trityaman, Chaturthaman, my lord. So 4 years, my lord. There's no concept of now there is some Ankur in some Shankar Vidyaloys. There are other classes, but in those times, my lord, it's Ka, Kha, Tritya, am I correct? Chaturtha, my lord.
As per this certificate, lordship, his date of birth is
88.
14th of February 1988.
It's okay, some days here and there doesn't mean 1988 is okay,
my lord.
but we're asking you.
Lordship, another aspect is, dear Lordship, it was issued in the year of November 2017, 25th of November 2017.
No, but the original register was brought in,
Yes,
that
Lord.
was exhibited. Right.
Sorry, was 1996 or
Lordship,
Can call for the record because we are not getting it.
Lordship. Lordship, below 40 বহি মতে তেওঁৰ জন্মৰ তাৰিখ আছিল ইংৰাজী 1900। Yes, Lordship.
This does not have it. This does not have it. That's why we'll have to call for the original record then.
Yes, Lord. Some education council must be here, Lordship. This school records, Lordship, may call for. School records may be called for.
We'll call for it, but this is a school, we'll have to get it to the police now, to the SP border.
Lordship. Yes, Lordship.
At page 66.
Yes, Lordship.
Doesn't have the date of birth.
Yes, Lordship. No. That may be called for, Lordship.
নাই নাই রেকর্ডত ডেট অফ বার্থ লিখা নাই রেজিস্টার অফ ডেট অফ বার্থ লিখা নাই যেটো ইয়াতে নেক্সট আছে কোন জায়গা আছে হ্যাঁ জায়গাটা কি আছিল না শোনিতপুর নাই একটু এই জায়গাটা মরিগাঁও 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 কিন্তু মরিগাঁও একটু মরিগাঁও
Plus SC school education. SC school education. Can you consider? Can you consider? Stop. We just wait, we will call the education department. No.
After some time.
My lord, my lord.
Upgraded item 35.
Mr. Ali,
Lordship.
the SPS filed an affidavit saying that you had approached them and they found out there's a mismatch.
Lordship.
And she was handed over to you, right?
Lordship.
Your wife has returned back.
Yes, Lordship. After 33 days, my lord. So before the wife and son, my lord, the victim, my lord, the police picked up them at about, my lord, 2 p.m. at night, my lord. There is no reference, there is no case. And why we met, my lord, they did not respond anything, my lord. And their whereabout was not informed to us about 1 month. Then we approached this on court. Now they're in the first order, my lord, my lord, order dated 7/6/2025. The instruction was that, my lord, we were declared foreigner. Lordship, kindly see, your lordship has already recorded, my lord.
All these things has been clarified, my lord, in para 5 and 6.
Why would someone who is not a foreigner be picked up? It is very.
This is not, my lord. And
It couldn't have been.
in, and my lord, the decay was my lord first principle, my lord, when it was the decay was my lord, the principle laid down by the Supreme Court, my lord. The first, my lord, principle, my lord, guidelines. The police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible and clear identification and name tag with their designation.
It is person for the questions asked.
Someone is, other affidavit has to be filed. Because how she was picked up? How many people went there to pick her up? What was the necessity of picking her? How did the identification was made?
Yes, but
What was the record with the person who picked them up?
And then you also tell why 2 AM. When these things, the affidavit is silent. We are putting the state to notice. Affidavit have to be filed by the authorities.
Lordship, let it come on day after tomorrow, Lordship.
So we'll have to issue a notice, otherwise this affidavit will remain. We are giving an opportunity to the police to tell us. But Mr. R. Ali, I'm counsel for the petitioner, as well as also for the respondents. Okay. Pursuant to directions issued by the court. On 21/7/2025. The superintendent of police, senior superintendent of police, within bracket border, bracket close from Golaghat, has sworn and filed an affidavit in opposition on 27/8/2025. Having perused the said affidavit, the court is inclined to observe that the said affidavit lacks relevant particulars as to the number of police personnel who had gone to the house of the petitioner to pick up his wife, namely, Muhammad, SSTT, Fatima Khatun, semicolon. What was the time of having her arrested? Again, semicolon. Who and how was the wife of the petitioner identified to be the proceedee of case number FTG 1722 of 2011. Which was disposed of by opinion dated 27/7/2020. No, but this is mean paragraph 5, page 16. What does it mean?
Lordship, that the deponent states that the office of the deponent themselves also made a scrutiny of the office in record in connection with case number so and found that the opinion dated 27/7/2020 passed in so was passed against Masammat Fatema Khatun, aged about 46 years, wife of Anwar
This
Hussain.
opinion was passed in FTG 1782.
Yes, Lordship.
Then why are these two other numbers referred?
Because Lordship, in the same name, two persons are there, Lordship.
Son was also picked up, my lord.
Why? Why?
Son took 200.
And son of the petitioner, namely Habiba, Habibar.
After receiving application, Lordship, they verified the case again, Lordship. After receiving the application from the petitioner, Lordship, they verified the case and found some identity was mismatched, Lordship. That is why, Lordship, it was happening.
Again, semicolon, the date and time when the wife and husband of the petitioner were released and handed over to their families. Semicolon. The date on which the office of the Superintendent of Police within bracket border, Kolkata, received a representation from the petitioner next paragraph, we are compelled to issue this direction to the respondent number 4, as none of the statements made in the affidavit filed on 27/8/2025 are borne by records. Next paragraph, standing also for the FT matters shall send a download copy of this order to the respondent number 5. It will be respondent number 4. Bring the order to the notice of the said authority. Full stop. The authority will not resolve, comma, as this court is inclined to direct the said authority to file an affidavit to bring on record the queries of the court. Next, list on. List on 15/10/2025.
That was fixed, Lordship.
15/10.
15/10.
Give it time. He's out.
Right.
You're there? In one of the cases, record has come, is 66 of this account. Let's take it up. We want the school register. We'll give you the details of the school. We require a register of the school. You have two ways to do it. Number one, either the original register can be bought. Second is if it's left open to you, you can also get a scan copy colored printout, because we need the date of and the date of birth is not registered here. But we want we don't want a black and white printout,
Color printed or original?
color printout or the original register.
Extra copy to bole. Bye. Maybe बोला गया something.
22/4/2022, I discarded
More than register to now.
exhibit
Copy to দিব।
মই বাইদেউ দি দিম।
A, comma, exhibit A within bracket 3, comma, which is the admission register, and exhibit A of within bracket 4, which is the relevant page where the name of the petitioner, comma, namely, comma, Farida Khatun has been entered. Full stop. The proved in original copy, which is available at page 66 of the tribunal's record, does not contain the date of birth of the petitioner. Next paragraph. Accordingly, comma, at the request of the court, Ms. S. Sudhir, and standing counsel for the school education department has appeared, and the court requests her to obtain a color printout of the scanned copy of the school register of, what is the name? Paschim Lengri. Lengri Bari.
LP.
Lengri Bari.
Lengri Bari. LENGRIBARI. Lengri Bari. LP school. Our village, Lengri Bari. Post office, Sohriya Gaon.
Pochim Lengri Bari. Pochim Lengri Bari.
That is the name of the school.
Yes, Mila.
That is not the address.
Yes.
Address is Lengri Bari.
Yes, Mila.
It was Lengri Bari. You're not putting Lengri Bari.
It doesn't say Paschim Rangbari. Achha, just say Paschim Rangbari, on the post office, Rabia Gaon. Post of, sorry, police station.
Moirabari.
Moirabari. Mahkama will be subdivision. Under the block elementary education officer, Lahori Ghat, district Morigaon. So, in the event, the court master shall provide a photocopy of the relevant page of the traveler's record just to enable the learned standing of the school education department to obtain the relevant record. So it is provided that in the event color printout facility is not available, or then the original register of the school admission for the year. Just send me that. Of the year 1994.
1998. 1998.
1998, she left the.
No, not this, 66. We are at page 66.
Yes, Lordship, 1992.
Be produced. So we'll make it clear that on after perusal of this register, the same would be returned. Next, the two copy of the order be provided to the learned standing council for the school education department to enable it to obtain it, obtain the same. Next part, list on.
I may be protected in the meantime, my lord.
How much time you will require?
After a week. After a week.
We are fixing it on 15 September.
Right.
So you have more than 2 weeks of
Right.
time. 15/9/2025. The quotation we are not giving you right now.
Copy of the requisition.
I will provide.
Okay. Give a.
I will
copy of
provide.
the quotation. We'll give you a scanned copy of this also.
Apply.
You just give a print out of that. You print out of basic 66 and a full copy of the order too. But the order and this copy will get it tomorrow.
Right.
The interpretation to the in the meantime, if the petitioner, namely so and so, is apprehended from she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border.
Sonitpur, my lord.
Sonitpur. The order to the notice of this list on 59/20. You have to rise, there is a single bench. There is a habeas corpus matter.
Yes, fine.
We'll fix it tomorrow.
Tomorrow at 2, my lord.
We are not saying. Oh, there's a, no, it will go to Thursday. Tomorrow there's a special bench. Habeas corpus matter. Give it on 4th.
Can it be mentioned at 2 in the evening, afternoon? If
We are listing it on Thursday. You make a mention in the morning.
my,
We'll make adjustment, but I don't want to write time in my orders.
my, I'm obliged. Well, at 43 maybe also well, on Thursday.
Just tell me, because I was.
কোনটো ফেজ দিব ইছানে সিকিউৰিটি পাব আজি আজি এইটো ক'লে আজি বাকি ঠিক আছে হৈ গ'ল ন হৈ গ'ল এই বন্ধ যাবি কন্টেন্ট চেম্বাৰ আজি টাইপ দি আছে
Order, delivery orders. Egg. Dia naik, saya ikut dia naik.
You were in this
Item 1.
1986.
Yes, Lord. Item 1.
Ah.
85, 19. Item 1 is 1985.
Item 1 is 1986. Bail application number 1986.
Lordship, I am.
Huh? Uh,
Item number.
1986, 1986.
Abbas,
Abbas Ali, another.
86, no?
This bail application is dismissed.
Lordship.
For item number 2, BA 570, there was the same order. The application is dismissed. There are some
Yep.
corrections
Lordship.
made over after some time. In the second case, Mr. A.M. Ahmed is there. Second
Is
case
not present.
was A.M. Ahmed.
Lordship.